Judge, I only got voicemail for Attorney Colum.
Okay. Mr. Williams, so I do not have your attorney yet. Are you able to text her or anything?
I tried to get in contact with her and it was going to voicemail.
Okay, so we can wait a little bit longer, or I can adjourn this a week or two to get her here. I don't know if you need to go to work or.
Uh, not at the moment, but I can try getting in contact with her again because last time I did speak with her, she was dealing with some personal issues,
Okay.
and
All right.
I talked to her this morning, and I gave her the code for I think it was for Judge Michael and he sent me another code for this court.
Did you send her my code?
Uh, I try to get in contact with her and I text her, but it's going to voicemail. But like the last call I gave her was for a different court.
All right, so I'm gonna email Judge Olsaver, and if she's in his waiting room or if she's in his waiting room, he can send her down.
Okay, thank you.
So. Just email him, Kelly. So we'll see. All right, Mr. Hernandez, we are just waiting for your attorney. So just be a moment, all right?
All right, Your Honor.
And Mr. Williams, I sent a message to Judge Olsaver. So I'm going to put you back in the waiting room and I'll check back in a couple minutes. All right.
Okay, thank you.
Thank you. Did you see our abuse neglect trial by drink? That's weird. Yeah. You get all excited because you get work done. I think I'm the least of P. Diddy's concerns right now. So you know, 80s and 52. Some people stop sign on Shepherd. That's what caused the accident. Yeah. I've seen so many cars go through that stop sign. All right, I have Mr. Hernandez.
No, I can proceed on the record. I don't need to speak.
Okay, so let me get Mr. Hernandez's file. Hold on, I gotta find it. Bunch of them. I don't know what I did. Oh, no. All right, this is in the matter of the people of the state of Michigan versus Pedro Hernandez Jr. We have 3 files, 24-21980 FH, which is set for arraignment today. And then we have 2 files for probation violation, 23-21325 FH and 23-21526 FH. I have Isaac Sneed appearing on behalf of the people, and I have Matthew Murphy appearing on behalf of Mr. Hernandez. So, Mr. Murphy, with regard to the file set for arraignment, do you waive the reading of the felony information?
Yes, Your Honor. We acknowledge receipt of said information, the witness list, and the discovery demand from the prosecution of this matter. We just ask that not guilty plea be entered this time and continued. And we'd ask if we could address, well, the other cases, Your Honor. Mr. Hernandez, there is 2 probation violation allegations, one of which stems from this new incident. Obviously at this point, we're still trying to figure out what we're gonna plead to in regards to that matter. So we're just asking for that to be adjourned. There was the other violation, as I placed on the record before, Mr. Hernandez was going to accept responsibility and plead guilty to that. If that was something the court wanted to accept, or we could adjourn that out to whenever we can deal with the other violation. Now, again, we're just asking for a pre-trial to be set in this matter. I want to talk to Mr. Sneed and confirm what they're offering, the prosecution is offering in regards to that file. And then we want to proceed with the plea on that. However, in the interim, I did want to address bond on the violations of probation. As I asked the court to address previously, I've had discussions with Mr. Coast about it as well. So I just wanted to place some things on the record.
So I do have Mr. Coast present. Mr. Coast, are you in your office?
I am, Judge.
Okay, so Mr. Hernandez is currently on probation for operating while intoxicated third offense, as well as, hold on, it's the other one, as well as assault with a dangerous weapon. And then while on probation for operating while intoxicated third offense, he now was arraigned today on another operating while intoxicated third offense. So Mr. Coast, I don't know, I think you met with him previously to assess him, is that correct?
I have not, Judge. I guess there was talk about him possibly going to inpatient, but nothing was directed for me to do anything at this time.
Okay, so Mr. Sneed, would you like to weigh in on bond?
I think the people's position, at least from Ms. McClure, is that bond should remain as is. Thank you.
Your Honor, we're asking for Mr. Hernandez to be allowed to be released to an inpatient. The CA at my office, Ms. White, she was trying to arrange that. Obviously, talking to Mr. Coast, he can't get anything done unless the court was to order that he could be released on bond to that inpatient. So that's what we're trying to have done. Obviously, if Your Honor does not want to be released to an inpatient, that's fine. But we're asking for the court to consider that. Is always, obviously, we're trying to get the case pending instead of sitting in custody in the jail. If you can go to an inpatient, which he hasn't had an opportunity to do before. So that's all we're asking the court to consider, would be allowing him to go to an inpatient facility.
All right, so Mr. Murphy, you can always have your office contact Mr. Coast to work with them. At this point, I'm not comfortable releasing him because of his continuous operating while intoxicated. I feel he's a danger to society out, and I'm not confident that he would stay at a rehab facility at this point. So I can have Mr. Coast do an assessment on the new file, and then you can have your staff contact him and we can discuss it later. So I will enter a plea of not guilty on file number 24-21980FH. And how far out do you want a pretrial on these?
Whatever, as soon as the court can find a schedule to do so.
My next available is November 6th at 8:30 in the morning.
Yes, Your Honor. And if I was going to a resolution before that, I'll contact the court.
Yes, thank you. All right, so Mr. Hernandez, and I'll do all three files together. I don't like piecemealing and stacking sentencings on box.
Thank you, Your Honor.
So Mr. Hernandez, we'll see you back on November 6th at 8:30 or sooner if something is worked out. All right.
Thank you, Mr. Hernandez. Thank you, Your Honor.
All right, Mr. Murphy, do you have anything else?
I don't see, Your Honor. I'm going to be over in Judge Olser, if I'm incorrect.
If you see Mr. Dagger Margosian, could you tell him I'm ready on Steinwettle?
Yes, Your Honor.
I'm here.
All right. Oh, he's already here.
Right there.
He snuck in. Okay. All right, so let me write the time down. All right. Okay, so let me grab the file. This is in the matter. Let me get her in. She's on Zoom. And Miss Holman, I am going to take your client next, okay? All right, so Madison Steinwettle, can you start your video and turn your audio on? Thank you. This is in the matter of the people of the state of Michigan versus Madison Steinwettle, file number 24-21814FH. I have, are you on this file, obviously?
I am.
Okay, Allison Arnold appearing on behalf of the people, and I have Michael Dagger Margosian appearing on behalf of Ms. Steinwettle. I do have in my file. Prosecuting attorney's sentencing guidelines scoring sheet. And I don't know if this is a victim impact statement. I shouldn't have this. Did you send that?
I think it was for the purpose of the cops, so I can take it back.
That goes to the probation department, and you can give it to him today, and then Mr. Degermer goes in. Okay, all right, so this is the date and time set for a pretrial, and Mr. Degermer goes in and Miss Arnold.
Your Honor, I'm gonna need a moment with Ms. Steinwaddell, if that's okay, in a breakout room.
Okay, so Ms. Steinbuttle, I'm going to put you in a breakout room with Mr. Degermer Gosian. All right, Mr. Lockton, can you hear me?
Yes, ma'am.
All right, this is in the matter of the people of the state of Michigan versus Rodriguez, Damon, Eugene Lockton. We have 3 files, 21-20524FH, 24-21769FH, and 23-21207FH. I'm gonna pause. Miss Underwood, you have 2 MDOC inmates who are in the building. Have you already met with them?
I am in the building, Your Honor, and I can come up and meet with them.
I don't know where they're at. Are they on first? They're on floor 3 if you want to.
Okay.
All right, thank you. All right, so Mr. Lofton, we are here today on probation violation. What?
Okay, yeah. I said I'm here in 20,000.
No, Mr. Lofton, hold on a minute. So I'm arraigning you. So I'm gonna tell you why you're here. I know you already know why you're here, but I gotta put on the record why you're here. And then I'll go through your rights with you, all right?
Okay.
Okay, so Mr. Lofton, we are here on a probation violation. One part of it is failure to appear at a probation violation hearing on September 11th of 24. And that is a contempt of court proceeding that can carry a maximum penalty of up to 93 days in jail. The second reason we're here is a probation violation where a request and summons was sent out to you alleging that you had violated the terms of your probation in that in two ways. One, that you failed to report as instructed on July 9 and July 16 of 2024 or anytime thereafter. In condition 1, it's alleged you were charged and arrested on 4 counts of police officer resisting and obstructing on January 9 of 2024. This is dated back in July, pending arraignment on August 14 of 2024. So it's the same probation violation on each of these files. And let me see here. Oh, wait. My bad. One of them is not a probation violation. One of them, hold on a second. One of them is your new file. I'm sorry. So 24-21769FH. That is a contempt of court for failure to appear for a pretrial. So that is still an ongoing felony case, and the pretrial was scheduled for September 11 of 24, and you failed to appear for that. So that's a contempt of court that can carry up to 93 days in jail. And your attorney, who was your attorney on that case? Was it Mr. Murphy or Mr. Dagger Margosian or who?
Well, I have a serious problem, ma'am. I will tell you right now that Jeffrey Lofton has been taking my court files, and he has been going to court with you guys somewhere.
That's not what I asked you, Mr. Lofton. My question for you
Well,
is.
he's stealing my files.
Okay, but Mr. Lofton, who's your attorney?
Michael Murphy, Matthew Murphy, but Jeffrey keeps stealing my court documents.
Okay, so Mr. Murphy's your attorney. That's good to know. All right, so on these violation of probation files, though, the maximum penalty, if you were to plead guilty on each of these, is up to, 15 years Let me see, what did you plead on this one? Did you plead? Is this another? Okay, that's another one. Wrong file, not 15 years. Don't panic. They're all 2 years for assault of a prison employee. So I've got you on probation for 4 counts of that type of offense, and you got new R&Os. So Mr. Lofton, are these R&Os too? No, the assault of a prison employee carries, hold on, the assault of a prison employee on file number 21-20524FH carries a maximum penalty of up to 5 years in prison. Mr. Lofton, do you want a court-appointed attorney on all of these?
I do, but I need to let you guys know that Jeffrey Lofton, who lives behind me, is coming to my house, taking my paperwork and showing up to these places as if he was me.
No, he hasn't.
Rodriguez
He has
Lofton.
never showed up. He has never showed up as
Okay.
you. So,
Okay,
Mr.
well,
Lofton, I am going to enter a plea of not guilty on your behalf. I'm muting you now, so I can't hear you anymore. I'm going to appoint an attorney to represent you, and I'm going to enter a plea of not guilty, and I'm going to set this over to, well, I'll try to hear it today at 10:30 if I can. Otherwise, I will set it over to tomorrow. All right. So we'll let you know when we're able to come back on it. Thank you, Mr. Lofton. You're all set. Or Mr. Rodriguez. Oops. No. Well, there's a lot.
Listen.
And he said Jeff Lofton's coming to his house, right? Okay. All right. So Miss Coleman, I am so sorry. Let me get your client in here. All right, Mr. Williams, I have your attorney. She's muted right now, which means she might be in another court. So we'll wait for Ms. Coleman to unmute her device. All right, I've sent her a request to unmute. So like I said, she might be in another court right now. So give her just a moment. All right, good morning, Attorney Coleman. I'm sorry about all the confusion and different Zoom numbers. So
Good
this
morning.
is in the matter of people of the state of Michigan versus Claudius Marcellus Williams. File number 21-2031 or 13 FC. So I have attorney Delicia Coleman appearing on behalf of Mr. Williams. This is the date and time scheduled for a probation violation. So Miss Coleman, how would you like to proceed today?
Just a moment. Good morning, Your Honor. Alicia Taylor Coleman on behalf of Mr. Williams. We're asking to adjourn this matter. Mr. Williams is going to trial on the new charges. And we believe that any decision by this court would be premature.
Okay.
I mean,
when is his trial?
Going to make payments to the court in regards to the underlying money, but the additional charges he is going to try.
Okay. When is his trial on the other matter?
October 28th.
October 28th. Okay.
Look, yeah, wait a minute. Hold on. Mr. Williams, what date is your trial?
They rescheduled me for another pre-trial on October 12th in the matter, and I'm assuming they'll go from there.
Yeah. He had to get new counsel, you know, for that matter.
Okay. So, all right. So I will set this over to November 6th at 8:30 in the morning.
Thank you.
And Mr. Coleman or Mr. Williams, if you can just make some payments on your fines and costs, please. And it'll be Zoom, and it's the same number, Ms. Coleman and Mr. Williams, same Zoom number as today. And we will see you.
I do apologize about that.
It's okay. And we will see you back on that day. Thank you both. You were both in Judge Olsaver's courtroom, so luckily I got your back. All right. Thank you.
Okay, thank you.
Thank you. Miss McGrain, are you in your office? Just send a message to Miss Dumont that we're ready for her. I will close the breakout room. And okay, Miss Dumont, I have Michelle Harding. She's been in my waiting room all morning. Are you anticipating seeing her today?
No, Your Honor, we were just gonna
All
set
right,
it.
let me bring her back in. And then Miss Adams, I believe, could you call the jail and tell them I'm ready on Cody date?
Okay.
See, Miss Harding hasn't been connecting, so.
I'm sorry, Judge, who did you want from the jail?
Cody Getch, it sounds, it's
Oh,
spelled
okay.
like Goach, but I think it's Gate.
Okay.
Right, Miss Harding's been on since about 8. She is not connected. I'm gonna send her a chat to connect to audio. Let's see. All right, in the matter of the people of the state of Michigan versus Michelle Lynn Harding, we have 2 files, 24-21779 FH and 24-21780 FH. I have Isaac Sneed appearing on behalf of the people and Katerina Dumont appearing on behalf of Miss Harding. Miss Harding is now connected to audio. This is the date and time set for a pretrial conference in this matter. Miss Dumont, how would you like to proceed?
Your Honor, between our last pretrial and this pretrial, we did have a Cobb's agreement that was done. We've explained the results of that to our client, but at this point, Ms. Harding would like to set for a settlement and jury trial date.
Right, well, Miss Adams, I'm gonna need, how many days? We will do file number 21779 first. And then the second file separately. It's a different date and transactions, 3/25 of 23 and December of 22. So it's different time periods and I've not received a request to join. So how many days do you think you'll need for trial in the first file?
Your Honor, whatever the prosecutor believes that they would need.
I would suspect at least 2, Your Honor.
All right. So Miss Adams, I think we're in March-ish, maybe February. Or you can bring me the book, it doesn't matter.
Available date would be March 25th, Tuesday.
Let me see, is that spring break? Let me look. So, yeah, the week of March 20 or spring break begins. So the week of March 23rd is spring break. So no, sorry. Right now, Miss Adams is saying, well, she didn't tell me about spring break and I've already scheduled stuff. Now I gotta go move all that stuff. That's what Miss Adams is saying right now.
So after that, Judge, we're looking at April 1st, Tuesday, April 1st.
April 1, Mr. Munn?
Yes, Your Honor.
Okay. All right, Mr. Sneed, this is a Miss McClure file, correct?
That's correct, Your Honor.
All right, April is a Tuesday, so it'd be a 9 a.m. start date. So I'm gonna set a final pretrial for March 12 on both files at 8:30 in the morning. I am going to require voir dire questions and jury instructions to be provided to the court by March 6th. No, yeah, March 5. March 5. And I will make March 12 a deadline for any motions in limine or any other motions. And that's filed and heard by, so I have filled out a scheduling order. We will get a copy of that out to both of you, and Ms. Harding, make sure you stay in contact with your attorney to prepare for trial, okay?
Thank you.
All right, thank you. So Ms. Harding, you're all set. All right, and Mr. Mott, I did call for the jail for Cody Gage. Are you representing him today too?
Yes, Your Honor. If I could just speak with him real quick to confirm what Mr. Daly told me.
All right, so are you anticipating a plea?
That's what he advised me of, but I
All
just
right,
want.
so Mr. Gage, I'm going to put you into a breakout room with Ms. Dumont. Go ahead and join that breakout room. And let's move back to Mr. Dagger Margosian in the matter of the people of the state of Michigan versus Madison Steinwettle. I do have in my file a prosecuting attorney sentencing guidelines scoring sheet. And so Mr. Dagger Margosian and Ms. Arnold, how do you wish to proceed today?
Your Honor, in speaking with Ms. Steinwedel, and obviously in speaking with Ms. Arnold, instead of putting Ms. Steinwedel through this, instead of putting the victim's family through this, Ms. Steinwedel does want to enter a plea of no contest as charged to count 1.
And that's for purposes of civil liability?
Correct.
All right, is that my understanding? And I know we had a bench conference on this, so I do have my notes from that. So is that no contest to count 1?
It would be, Your Honor.
All right. Okay, so Ms. Steinwettle, you want to raise your right hand? Thank you. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, and can you state your full name for the record, please?
Madison Steinwedel.
Steinwedel. All right, thank you. And you can put your hand down. So Ms. Steinwaddell, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest to count one, reckless driving causing death, which carries a maximum penalty of up to 15 years in prison and or a fine of anywhere from $2,500 to $10,000 with a mandatory vehicle immobilization as well as reimbursement for emergency response and expenses? So is it your intention to plead no contest to that count?
Yes.
Are you satisfied with Mr. Dagger Margosian as your attorney and the advice that he has given you?
Yes.
We did have a bench conference about this case and the prosecutor has provided the sentencing guidelines. But other than that, Mr. Dagger Margosian and Ms. Arnold, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Ms. Arnold?
Correct, Your Honor.
Mr. Dagger Margosian?
We discussed it, but as far as any sentencing agreements, correct.
Okay. And Ms. Steinwaddell, is that correct as far as you're aware?
Yes.
If a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Ms. Steinwaddell, do you understand it that if your plea is accepted, you may be giving up the right to any appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I have given to you?
No.
How do you wish to plead to the charge that on or about March 15 of 2024 in Ridgeway Township, located in the county of Lenawee, that you did commit the offense of reckless driving causing death? No contest or not guilty?
No contest.
Okay. Has anyone made any threats or promises to you to induce you to plead no contest to this charge other than what was placed on the record?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? Ms. Arnold?
We are not, Your Honor, but there is, looks like a date error in the information. The date should be January 29th, 2024.
Would you agree with that, Mr. Dagger Margosian?
I agree with that, Your Honor.
It was charged correctly in the complaint. I'm not sure how the date got changed in information.
Okay, so you'll amend that today?
We will.
Okay, all right, so I think I was asking as prosecutor or defense counsel.
We're not aware of any threats, promises, or inducements other than what's been stated on the record.
All right, Mr. Dagger Margosian?
None, Your Honor.
Has your attorney promised you any particular sentence or estimated what your sentence will be in terms of incarceration, fines and costs, or any parole or probation?
No.
Is it your own choice to plead no contest?
Yes.
All right, who will be placing the factual basis on the record?
I can, Your Honor.
All right, thank you, Ms. Arnold.
This comes from Lenawee County Sheriff's Office, incident report number 2400012390-01. It shows that on the charge date of January 29, 2024, at about 9:28 in the morning, the defendant was on M50 in the area of Brixham Highway. At that point, she was in her vehicle. She crossed the center line. Two drivers had to completely get off the road to avoid a crash with her. She hit the third person in line, a woman by the name of Eileen Christophers, was 55 years old. Mr. Christophers was killed on scene, and the cause of death was by autopsy, the motor vehicle accident. Forensic analysis of Ms. Steinwettle's phone was done. Ms. Steinwettle gave consent for law enforcement to take her phone and search it. I believe she provided the code for her phone also. That was done by Danielle Vanden Heuvel of the Michigan State Computers Crime Unit, who is an expert in cellular phone analysis. It showed that videos were being played on Ms. Steinwettle's phone for some time period before the accident, videos from social media, and that she had to change from one video to another from her phone through the phone's function. The last video she was watching is one that the Computer Crimes Unit reviewed, and it was a video that did not have much audio narration, showing circumstantially that Madison was watching that video. So we believe that would support recklessness on the date and venue in question causing the death of Ms. Jeffers. I'm sorry, Ms. Christophers.
What was the date again?
January 29, 2024.
Any additions or objections, Mr. Dagger Margosian?
I think in Miss Arnold's recitation, she may have said Mr. Christophers, but that
she corrected it. Yeah.
Yeah, that's the only thing. Nothing further.
All right. So based on the facts placed on the record and from the information contained in the police report as stated on the record, the court finds beyond a reasonable doubt that on January 29th of 2024 in Ridgeway Township in the county of Lenawee, that the defendant did commit the offense of reckless driving causing death by crossing the center line and actually causing two cars to go off the road and hitting the third vehicle where the driver of that vehicle, Eileen Christophers, was killed. The autopsy showed that her cause of death was from the automobile accident. And there is evidence that she in fact was on her phone watching videos while driving. And I think that satisfies the reckless driving statute, and therefore the court will accept the no contest plea. Has the court complied with MCR 6.302 B, C, and D, Ms. Arnold?
Yes, Your Honor.
Mr. Dagger Margosian?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I am going to refer this matter to the probation department for a pre-sentence investigation. Ms. Steinwettle, I'm going to set sentencing for November 22nd at 8:15 in the morning. You will be required to come in person that morning, Ms. Steinwettle. And I'm going to put you in a breakout room with Ms. Holly this morning, and Ms. Holly will give you information on how to proceed from here. She'll set up a time for you to come meet with them in person. When you meet with them, be truthful about your background. Obviously, you entered a no contest plea for civil liability purposes, so you do not need to make a statement about the events that occurred. And we will see you back then on November 22nd at 8:15 in person. So Ms. Steinwettle, I'm going to open up a breakout room. Mr. Dagger Margosian, do you wish to join the breakout room?
Just briefly, Your Honor.
Okay, so Ms. Holly, Ms. Steinwettle, Mr. Dagger Margosian, go ahead and join that breakout room. Okay. All right, November 22nd at 8:15. I'll try to take that one first. All right, Miss All right, it's Gage, right?
Yes, ma'am.
Okay. This is in the matter of the people of the state of Michigan versus Cody Wayne Gage Senior, file number 24-21921FH. I have Katerina Dumont appearing on behalf of Mr. Gage, and I have Isaac Sneed appearing on behalf of the people. I have a pretrial assessment that Mr. Coast prepared dated September 3rd of 24. Where Mr. Coast prepared or did a pretrial assessment. He's currently in jail on assault and child abuse charges. He's been in jail at that time for about 2.5 weeks on a $45,000 bond. Mr. Gage scored a 3 on the assessment, which puts him in a low to moderate range to fail to make court dates in the future or reoffend while out on bond. He was working full time at the time of his arrest. He has not failed to report at any time in the past 2 years. He is not a current drug user. He did have some points because of his prior criminal history. He is on probation currently with Mr. Jones through the Michigan Department of Corrections. Mr. Jones states that Mr. Gage was compliant for the most part. And he believes, and Mr. Jones stated that the bond was appropriate. All right, so Ms. Dumont, how do you wish to proceed today?
Your Honor, we have a pretrial offer where Mr. Gage would plead to count 2. There would be an added count 4 of a domestic assault. Counts 1 and 3 would be dismissed with an agreement for jail time to cap at 6 months, no MDOC.
All right, so he would plead to count 2, child abuse 3rd degree, an added count 4 of domestic violence. Would that be a first? So 93-day domestic violence?
Yes, Your Honor. Oh,
That's
Mr.
not
Sneed,
accurate.
what is the plea, Mr. Sneed?
The added count 4 is a domestic violence 3rd offense, which is a 5-year felony.
okay.
Is that not what you, I know Ms. Dumont's filling in for Mr. Daly today, so.
I was just looking at the notes. I know Mr. Daly went and talked to Mr. Gage, so.
Mr. Gage, domestic violence 3rd, that's a 5-year, correct, Mr. Sneed?
Yes, Your Honor.
So, Mr. Gage, when Mr. Daly came and saw you, and obviously I'm very grateful for Ms. Dumont filling in today. So the plea offer is count 2, child abuse 3rd degree, that carries a maximum penalty of up to 2 years in prison and up to 5 years probation, and then an added count 4, domestic violence 3rd, which carries a maximum penalty of up to 5 years in prison, but they would run together. Is that the plea offer that Mr. Daly spoke to you about?
Yeah, he said that there would be no MDOC and it would cap at 6 months in jail time if I pled to it.
Mr. Sneed, is that correct?
Yes, it is, Your Honor.
Okay, so do you need to talk to Ms. Dumont again, or are you understand the plea offer?
I think so.
Yeah,
Your Honor, we don't have a signed plea agreement back yet from either counsel or the defendant, so it may be nice to have that. So we understand.
I'm gonna have one all morning and I've met a bunch of people. I can set it over to 1 o'clock, but Mr. Gage, so the plea offer is child abuse 3rd degree, which carries a maximum penalty of 2 years, and domestic violence 3rd, which carries 5 years. There is a cap of 6 months jail and no Michigan Department of Corrections. That part's correct, Mr. Sneed?
Yes.
There was no other terms to that plea?
No.
Your Honor, and like I
Mr.
said,
Gage?
Mr. Daly went and spoke with him last week with regards
Okay, so Mr. Gage, are you willing to enter that plea today?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth? Keep it up. The truth, the whole truth. No, you gotta hold it up. Just because I put my hand down, I'm not getting sworn in. You are. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. So, Mr. Gage, you fully understand the plea offer?
Yes, ma'am.
And is it your intention then to plead guilty to count 2 child abuse 3rd degree, which carries a maximum penalty of up to 2 years in prison, and count 4 domestic violence 3rd, which carries a you can put your hand down now actually, and to count 4 domestic violence 3rd offense, which carries a maximum penalty of up to 5 years in prison. So it's your intention to plead guilty to that?
Yes,
All right. Are you satisfied with Mr. Daly and Mr. Duman as your attorney?
yes,
All right, other than the 6 months in jail cap and no Michigan Department of Corrections sentence, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
And Ms. Demont?
Yes, Your Honor.
And Mr. Gage, is that correct?
yes, ma'am.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, ma'am.
So, Mr. Gage, how do you wish to plead to the charge that on or about July 16th of 2024 in the village of Addison in the county of Lenawee that you did commit the offense under count 2, child abuse 3rd degree, guilty or not guilty?
Guilty, ma'am.
And on count 4, domestic violence 3rd offense, guilty or not guilty?
Guilty.
All right, and would the aggravated stalking satisfy the prior domestic, or do you have a date for a prior domestic on your paperwork, Mr. Sneed?
Well, Your Honor, we didn't have a chance to prepare that since we didn't know he was pleading this morning, but looking at his criminal history, there's a domestic violence conviction from September 15th of 2016. There's also the stalking from September 15th of 2016. There's also a stalking from February 15th of 2023. And an assault and battery from November 21st, 2022.
All right. So, Mr. Gage, so are those your prior domestic incidents that you pled guilty to on September 15 of 2016? There were 2, February 13th of 23, and then the assault and battery, I think that was pled down on November 22nd. So are those your prior convictions for domestic assault?
Yes, ma'am.
Okay. All right.
If I could address the court, Your Honor.
Yes.
Whether or not the stalking and assault and battery would qualify to justify the domestic violence 3rd offense, the domestic violence 3rd offense being a 5-year felony is a reduction from count 1, which is a 10-year assault with intent to do great bodily harm or by strangulation. So Well, we would be satisfied with a plea to the greater elements to satisfy that lesser domestic violence third charge.
So do you understand, Mr. Gage, that that's a reduction from the assault with intent to do great bodily harm less than murder? For purposes of a plea, it's a domestic violence third, taking it from a 10-year with higher guidelines to a 5-year with lower guidelines?
Yes, ma'am.
Okay. Do you have any questions about that?
No,
So has anyone
Sure.
made any threats or promises to you to induce you to plead guilty to these charges?
no,
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
yes,
Is a prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Sneed?
No, Your Honor.
Ms. Demont?
No, Your Honor.
So other than the agreement that was placed on the record, Mr. Gage, has your attorney promised you any other particular sentence or estimated what your sentence will be?
no,
Is it your own choice to plead guilty?
yes, ma'am.
So, Mr. Gage, on July 16th of 2024, were you in the village of Addison in the county of Lenawee?
Yes,
Okay. And at that time, were you in the presence of, let me see here. So Mr. Sneed, is the individual listed in count 1 with the initials SKG a minor or an adult?
That's an adult, Your Honor.
Okay. And then, okay, I don't have any information on the minor, but so sir, were you in the presence of a child?
yes,
All right, and did you kick a door and destroy the door that was close to the child?
yes,
And was the child harmed? Like, was the child struck with pieces from the door?
yes,
All right, and did the child receive any injuries, cuts, bruises?
yes,
Okay, and you intentionally kicked that door, is that correct?
yes, ma'am.
And the child was standing next to it?
Yes,
We didn't get that last answer, Judge.
Was the
Yes.
child standing next to the door? Say it again.
yes,
Mr. Sneed, anything to add on count 2?
No, people are satisfied. Thank you.
All right, now, there was also an adult, a woman with the initials of SG that was present, and did you assault her?
yes.
Okay, can you tell me what you did? It says by strangulation or suffocation. So can you tell me what you did when you assaulted her?
When during the assault, at the time I was trying to hurt myself, and she grabbed a knife from me, and I pushed her off of me and grabbing her neck and grabbing her, throwing her off of me.
So when you grabbed her neck, did you squeeze?
No, ma'am, I just grabbed her and threw her off of me.
Okay, was she injured?
Yes. From what I
And
was
would you
told.
agree, would you say that by grabbing her by the neck, that put pressure on her windpipe?
No, ma'am, I grabbed her by her neck to throw her off of me.
Okay, well, if you're gonna grab someone by the neck to throw them off you, you must have used some force on her, is that correct?
Yes,
Okay, and would you agree that that force would have made her feel that she was in danger of strangulation or suffocation?
yes,
Mr. Steen?
People are satisfied, Your Honor. Thank you.
Has the court complied with MCR 6.302B? And that was for the purpose of, that plea was taken to the elements of count 1 for the purposes of the count 4 domestic violence third offense. All right, has the court complied with the MCR 6.302B, C, and D? Mr. Sneed?
Yes, thank you, Your Honor.
Ms. Demont?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the agreement that was placed on the record. I'm going to refer this matter to the probation department for a pre-sentence investigation. And I will set sentencing for November 22nd at 8:15 in the morning. Mr. Gage, you do have the right to appear in person, or you can appear via Zoom from the jail. How would you like to appear?
Through Zoom.
Okay, so we will set that via Zoom. Mr. Gage, someone from the probation department is going to come over and meet with you. Be truthful with them about the events that occurred and your background. They'll prepare a pre-sentence report. It'll probably be Chris Jones. We'll get a copy of that to Ms. DeMont, and she will come review that with you before sentencing, and either her or Mr. Daly, and then we will see you back on that day. Thank you, Mr. Gage. Thank you, Mr. Sneed.
Your Honor, if we could address one thing really quickly. Mr. Gage wanted to ask the court if his current no contact provision with his minor child, his son, could be amended to allow for him to do some sort of FaceTime or virtual visits. He is working with CPS and DHS. Their goal is reunification, and he is taking classes and following any orders that they have. But he would like the ability, if they do allow him to have some supervised parenting time, if he could do that.
So they're not going to give him supervised parenting time at the jail?
Well, I mean, via, Zoom or FaceTime or something.
I don't know. Mr. Sneed, I've never known CPS to do video visitation at the jail. They might, I don't know. Mr. Sneed, you want to weigh in?
They don't, to my knowledge, Your Honor. I would defer the decision to the sentencing date, and possibly the defense attorney could get more information from CPS and what their recommendations might be regarding that visitation.
So, Ms. DeMont, if you can get verification that CPS would set that up, we can do a bench conference real quick. If it's something that CPS is recommending, we can definitely address it by just doing a bench conference, okay?
Sounds good, thank you.
All right, thank you, Mr. Gates, you're all set.
Thank you.
All right, and Ms. Underwood, I have a couple of pickups after we have a next, okay.
I'm aware of that, You're on.
All right, so who do you want to take first, Ms. Underwood? Mr. Gonzalez Rodriguez, or do you? That's fine, okay. Get your paperwork, hold on one moment. Mr. Dagger Margosian, in the matter of the people of the state of Michigan versus Chad Everett May, file number 24-21847FH. I have Michael Dagger Margosian, I have Isaac Sneed on behalf of the people. I do not have Mr. May. I do show arraignment was waived. And I do show that we mailed a notice of hearing to his address on Circle Drive. But he is not here, Mr. Dagger Margosian. You want to reach out to him?
Your Honor, he's in the middle of a medical procedure. I'm in contact with his wife. He's doing economic crimes unit court, and he's made a payment. I figured I would just ask the court to adjourn this pretrial, and I would maybe a month, I think, would probably be fine. He's on course with making the payments, and so
okay. How about November 27?
Yeah, that's fine. And
you do the stip in order?
I'll do the stip in order. I'll contact him. I don't know if the court also wants to send a notice or how that's going to work, but I'm happy.
You got to send the notice.
It's fine. I'll contact him.
Okay. All right. So, all right, you can do the stip in order. Mr. Sneed, can you sign your name with permission?
Yes, thank you.
All right, and we will see you back on that day. Thank you, Mr. Dagger Margosian. All right, so get your file. This is in the matter of the people of the state of Michigan versus Jonathan Gonzalez Rodriguez, file number 23-21565FH. I do have Rhonda Underwood appearing on behalf of Mr. Gonzalez Rodriguez. I requested in person because the last time we were here, we were unable to hear you at all. So that's why you're here in person. I have Isaac Sneed on behalf of the people. So Ms. Underwood, how do you wish to proceed today? On behalf
Your Honor, the offer to Mr. Gonzalez Rodriguez is plead guilty to one count with one sub, Your Honor. The second count and the rest of the habituals would be dismissed. I've discussed that offer with Mr. Gonzalez Rodriguez. He, at this time, does not wish to accept that offer.
Okay. So the plea offer is to plead to count one, assault of a prison employee, which carries a maximum penalty of up to 5 years in prison with one sub, which makes it, what, a 7.5 year? Okay. And dismiss count two along with his habitual offender fourth offense notice. So Mr. Gonzalez Rodriguez, do you understand if you go to trial and you get convicted, you're looking at a life sentence? Okay, so you understand that? Okay, and you don't want to take the plea offer? Okay, so you want to go to trial? Okay. So Ms. Adams, he is in custody. This is probably a 1-day trial. So when's your out? When are you eligible for parole or your out date?
August 15th.
Of next year?
Yeah.
All right, so Ms. Adams, 1 day, I don't know if we have time before the end of the year or January, February, or you can bring me the book. And you understand, Mr. Gonzalez Rodriguez, that this stacks on any current sentence you're serving, right? Okay. December's all that. What do we have one day in January? You're gonna have this. Have you received all your discovery?
I believe we have, Your Honor.
Okay. Is there any video?
There is video, Your Honor.
Has he had an opportunity to see the video?
He looked at it in my presence today.
Okay.
I believe he's seen it before too.
All right, so you got to watch the video? Okay, good.
You didn't get it, I'm not picking them up.
All right, can you say that a little bit louder for me?
Yes, ma'am.
All right, thank you. We have to record everything, so.
Don't have a day in January without moving something.
February is fine. He's in till August of next year, for sure, anyway.
Thursday, February 27th.
Are you available? February 27th?
February 27th.
Are you available that day?
If she's supposed.
Okay, so I will set this for one day. I will set a final pretrial for February 12th of 25 at 8:30 in the morning. And I will require that jury instructions and voir dire questions be filed by February 5 of 25. And I will make February 12th final motion date, filed and heard by. Okay. And can I give him a copy of this today? Okay, so Ms. Adams, could I get a copy of this for both Ms. Underwood and Mr. Gonzalez Rodriguez? So, and Mr. Gonzalez Rodriguez, I don't care at the end of the day if you go to trial or you enter a plea. Do you understand?
Yes, ma'am.
But I'm just letting you know that if you get convicted, the sentence would be well over 25 years in prison, and it would stack on what you're serving now.
Yeah.
Okay, and if you were to take the plea offer, you're probably looking at only a couple years getting stacked on your sentence. Do you understand that?
Yeah.
Okay. All right. So Miss Adams is going to get a notice for you, so you can have a copy of the paperwork. All right. All right. So why don't you go have a seat back there, and we'll give that notice to the people who brought you over.
Gonzalez Rodriguez, we really need to do that, okay?
Okay.
Because this isn't good, okay?
Miss Adams, you can hand it to transport. All right, thank you, Mr. Gonzalez Rodriguez. All right, so Ms. Underwood, your next person is John Mike Shelton. So, Brenda.
Yes.
Did you want to talk to him before he left?
Do you want to talk to him today?
Okay, very good.
Not before you leave.
Okay. Mr. Shelton, you want to go up by your attorney? Lindemann. There. Okay, this is in the matter of the people of the state of Michigan versus Del Mike Shelton, file number 24-21695FH. I have Brenda Underwood appearing on behalf of Mr. Shelton. Mr. Shelton, okay, we have Phoebe. Are you on this one, Ms. McClure?
Yes.
I'm sorry.
Yep.
All right, I have Brenda Underwood appearing on behalf of Mr. Shelton and Phoebe McClure appearing on behalf of the people. This is the date and time set for a pretrial. And I do see that we received a report on the forensic evaluation of competency on July 1. I see an order for criminal responsibility and I have a letter saying that there's been a delay. Have you received the criminal responsibility?
I don't believe we have.
Yeah, the last piece we received was on July 1st that it was delayed.
Yep, and then I have a memorandum from Thomas Boyd, who's the state court administrator, stating that, again, judges are reporting long delays in competency and criminal responsibility evaluations completed by the Center for Forensic Psychiatry, and discussing the legal standards. So in this case, we have not yet received it, and I don't have any updates on it. I know I used to volunteer at the Forensic Center and they've cut staff, so I haven't received a criminal responsibility.
Your Honor, I've talked to Mr. Shelton. There is a motion that we're preparing, Your Honor. We would ask for another pretrial in probably 40 to 60 days. Your Honor, by that time, our motion should be heard. And maybe we'll hear something from the forensic center too.
Okay, and then I'll see if hold on one second, let me say one more thing. So, Miss Underwood, we will try to find a resource to follow up on that. I don't know if the prosecutor has resources to follow up on the criminal responsibility, but we will definitely do that. So you wanted to say something to me? Or do you want to say it to her first and then let her tell you whether it's something you should say to me? Because it might work against you. You know what I mean?
I'm sorry.
Miss Adams, if you can get the jail on Coke and Pedro, or Matt Murphy maybe on Pedro Hernandez.
Your Honor,
oh, it's Rodriguez Lofton, never mind. What, Miss Underwood?
What did you not say? He's talking about a transcript.
Okay,
Your Honor.
pull the mic, or can somebody adjust the microphone for him? What are you looking for? As long as it was something not related to the case. I just don't want you to say something that might work against you. So you want a transcript?
My transcript, discovery packet, and
okay.
Register of action, please.
Okay, so let's start with the transcript. Did you hold a preliminary exam?
We did not hold a preliminary.
Okay, so there's no preliminary exam transcript. So the only transcripts there would be probably when you waived your preliminary exam in district court, and then the motion for competency and criminal responsibility and the pretrial. So what transcript are you looking for? You got to speak up for me. I'm so sorry.
That mic needs to be adjusted.
Somebody move the mic up. So we record all this so that we can make transcripts. So it's really important. It's like the only time you're allowed to yell at a judge. Okay. So what transcript are you looking for?
Well, I'm just looking for a transcript to help me on my case.
Okay. So we don't have any court proceedings that are hearings where testimony was taken. So we can get transcripts of the pretrials, but nothing of any substance has been put on the record. Miss Underwood, the discovery packet you received from the people, have you?
Mr. Shelton has been sent everything.
Okay, so Miss Underwood said she has sent you everything. Do you have a copy of the police report? So that's probably your discovery packet right there. Is there something you're specifically looking for?
For the witness statement, I don't see the witness statement.
Okay, Miss Underwood?
I believe the statements are in there, Your Honor.
Okay, so I know that when I was a criminal defense attorney, sometimes my clients were like, well, you know, I want discovery, and sometimes discovery is just a police report and there's statements that were given to the police officer. But a lot of times my clients thought they would be handwritten statements and they weren't. So, yes, sir.
I read it, well, I can't read like that, but I had somebody else read it to me, and all I see is the police, the officer's statement. I don't see nobody's statement, and several people said that they seen the incident.
Okay, so the police officer put in the report what people told them, but you're saying other people have told you that they saw the incident?
Yes.
Okay, and they weren't interviewed by the investigator?
They said they seen multiple witnesses, co-workers, nurses.
Okay. Okay, so the witnesses that the people have provided on the felony information. Let me pull that up. So the felony information always, which you have a copy of, you got a copy of the felony information. It lists witnesses. So the raised gesti witness is a Corey Keller. Is that a correction officer? Yes. And then the other witnesses are Trooper Dan Drew, who's probably the MSP officer who took the incident report. And then a Jonathan Monahan, a Colin Owen, a Jamel Smith, a Nathan Adams, a Scott Gallagher, a Jared Gonzalez. So those are the witnesses, and the people say that they intend to call Nathan Adams, Trooper Drew Yor, Scott Gallagher, Jared Gonzalez, Corey Keller, Jonathan Monahan, and Colin Owen, and Jamel Smith. So those are the witnesses that the prosecutor intends to call. Are those the witnesses that you're referring to? Okay. Did the police officer summarize what they told them in the police report? Okay. All right. So they'll be called to testify. So Miss Underwood, she'll reach out to Miss McClure to see if there's anything else by them, I'm sure, because that's her job and she always does it. Yes, sir. Yeah, speak up for me.
Another thing, I need my register of action form, please.
Okay, I can get you a copy of our register of actions from circuit court. Miss Adams, I don't think we can print the district court one, right?
I do not have access to district court. I can see if we can get it.
Can you print off ours?
Yes.
Okay. Miss Spade. Miss Spade might be able to print the district court one. Would you like that, Miss Underwood?
That's fine.
All right, can we print 2 copies, one for Miss Underwood and one for Mr. Shelton? What else, Mr. Shelton? Gotta speak up for me.
Can I say on the record?
Well, you are on the record.
On the record, the prosecutor said 180-day ruling don't apply to prisoners. That is
the prosecutor, you got to speak up for me. I'm so sorry.
Said that 180-day ruling do not apply to prisoners. And my question is, how is that?
The 180-day rule does not apply to prisoners.
This is what the motion, that is
okay.
What our motion is concerning is the 180.
Joanne, I don't know if you have access to my printer 9.
I have.
Judge, I do. I'm using it.
Circuit court.
That's circuit court.
Right.
And Miss, okay, so there's that.
That's what our motion.
Okay, so your attorney has filed that motion, but she has to set it for hearing. So she's filed the motion you're asking for. That's the ROA, and I think the transport officer has that for you. And then Miss Spade is printing off the one from district court or Miss McGrain. So we'll get you that one too, okay? Yes, and then we'll, Miss McClure or my staff, we're gonna try to follow up. For district court?
Yeah.
Looks like January 30th, probably. Oh, perfect. So Miss McGrain has printed the district court. So she'll give one to Miss Underwood, and Miss Underwood will give a copy for you to your transport officer. Thank you, Miss McGrain. And so you got that, okay? And then Miss Underwood filed the motion like you asked. She is filing the motion that you're asking about, and we will hear that at your next pretrial. When did you want the pretrial?
Why don't we do 45 days, Your Honor?
They'll give you enough time to file it,
Yeah.
Ms. McClure to respond?
It's ready.
Okay, so is that all right, Ms. McClure?
That's fine, and I just wanted to place the updated plea offer on the record as well.
Okay, there's an updated one, okay.
Yeah,
There
I don't
has
know.
been a plea offer, Your Honor. It is as charged with one sup, as I understand it, which would make this a 7.5-year felony.
Okay, so.
No, Ms.
Mr.
Underwood and I spoke this morning and I agreed to reduce the plea offer. That was my former plea offer. But after our discussion, I had agreed to reduce that to a different plea offer.
What's the new plea offer?
To an attempt with no subs to account for the delay in charging and also the fact that it's ancillary to another incident involving other prisoners.
All right, so Mr. Shelton, there's been a new plea offer made and you're, okay, because there was a delay in, I don't know what happened because I don't know the cases. Miss Underwood now has that information. Do you want to talk to him? Or do you want me to explain it to him on the record?
I would ask, I believe if it's an attempt, Your Honor, I would ask for a COPS agreement to the low end of the guidelines.
I always sentence to the low end of the guidelines on these. So, Mr. Shelton, the plea offer
that's what we discussed, Mr. Shelton. The lowest end of the highest that grid can go on the lowest end is 5 months.
So, Mr. Shelton, so the plea offer that was made this morning has changed. So it's an attempted assault of a prison employee that carries a maximum penalty of up to 2.5 years in prison. All right, that's a maximum penalty, but there are guidelines that are run. Are you familiar with guidelines? Yes? Okay, so the plea offer is to the low end of the, or to an attempted, the low end of the guidelines. I don't have the guidelines, so I don't know what they are.
Your Honor, the highest in that grid, the low end is 5 months, I believe.
All right, so the guidelines are pretty low. Whatever the sentence is, though, would stack to whatever you're serving now. Do you understand that?
Yes, ma'am.
Okay, so we have a couple options. You can talk to your attorney today, and if you want to take the plea offer, I'll take it today. So just to help you out, do you want a moment to talk to her?
Yes, ma'am.
All right, so she can talk to him in the hallway if you're comfortable with that. So they're gonna take you to my little hallway right here, okay? And give you a chance to talk to Miss Underwood. All right. Mr. Cook, it'll just be a few minutes, okay?
You're
just
okay.
Be
You're
patient.
fine.
All right, thank you. Is your client here? Oh. Okay. Yeah. If he won't cooperate, I'll see him tomorrow.
He won't go upstairs, so we can.
Okay, I don't want to see him then. Okay, it's just being a pain. You can be a pain. Okay. So we'll try again tomorrow. Tell Becky to set it sometime tomorrow. That'll work. No, he's a all right. Okay, let me find this performance file. All right. Miss McClure, you're here on McCormick. So. Let me look what I got at 8 o'clock. I don't have trial till tomorrow at 10:30. So 8 o'clock's fine. Okay. Okay. Council, all right, so this, do I have Miss McClure, are you in your office?
Yes.
Are you ready on McCormick?
Let me check.
It's a motion at 10:30.
Mr. Sneed.
Either of you on the 10:30 motion on McCormick?
Oh, that is Jen, Miss Bergman. Is she? not logged in. I can give her a call.
No. Okay. Okay, can you guys both move again? Thank you. All right. Mr. Shelton, why don't you go back up to the podium? Huh? Okay. Oh, Justin. Never. Okay. All right, so give us just a moment and we'll get Miss Underwood back, all right? Yeah, she knows how to get in. She usually she doesn't know to use that door, but yeah, just let her in.
Judge, I sent you a chat message.
Sure, 1:30 is fine. If Miss Underwood can do it. Oh, there's Miss Bruggeman. Miss Bruggeman, are you on McCormick?
Sorry, Your Honor, I had to turn up my volume. Were you just talking to me?
Yeah, are you on the motion at 10:30 on Wesley McCormick?
Sorry, it was on my calendar wrong for the wrong court, so I was confused.
Okay.
Sorry about that.
All right, so we are back on the record with Mr. Shelton. Miss Underwood, were you able to talk to Mr. Shelton?
I was, and I was able to confirm what I wish. Your Honor, I've explained to Mr. Shelton the offer. As I've explained to him, the charge would be taken down from an E grid to where it currently is, to an H grid. And the worst low end on that is 5 months, Your Honor. And Mr. Shelton wishes to accept that offer, Your Honor.
Okay, so Mr. Shelton, remember how you asked for a transcript earlier? That's why we have to speak loudly because Ms. Spade would prepare the transcript. So do you understand the offer that was made today?
Yes, ma'am.
So you would be pleading to an attempted, so count 2, attempted assault of a prison employee, and Ms. Underwood, there would be no subs. And Ms. Underwood explained the guidelines to you? Okay, and you understand that'll stack to the sentence you're currently serving? Okay, so it means you wouldn't serve the 5 months, 6 months, whatever we give you on this case until you finished your sentence on the case you're currently serving on. So do you understand that? Okay, we're still waiting for criminal responsibility, but the competency came back that you are competent. So you want to take that plea offer today? Do you want to plead today or no?
You want to take that offer?
Or do you have a question for me? Do you have a question? What's your question?
My question is, I'll take the plea. I'm not serving no time. I'm just basically on dead time. This time don't count.
So you're saying you're flopped right now?
Yes.
Okay, so once you enter the plea and get sentenced, your parole board or whoever is in charge of you within the Michigan Department of Corrections will either give you credit for any of the time you've served towards your prior offense. They could give you a little bit more of a sentence. I don't know. I have no control over that. But whenever that sentence ends, then you would serve the sentence on this one, which Ms. Underwood explained the guidelines are pretty de minimis. So it would stack on top of that. So you could, at the day of sentencing, they could end your sentence on your current incarceration and you would start your new one, or, you know, I have no control over that.
I have another question.
Yes, sir.
How is it that they trying to get me to plead to they violated my rights. That don't make that make sense. It don't make sense.
Okay, so I don't know if you're alleging that MDOC or employees there violated your rights, or if you're referencing the 180-day speedy trial. What I will tell you is that when a forensic exam when there's a request for a forensic,
Oh, I'm sorry.
that kind of stops time on the 180 days. Is that correct?
Well, but that's not what we're dealing with here.
Okay.
This was a delay.
And charges. Okay, so Ms. McClure said that the reason she did reduce this plea is because of the delay in charging. So that's what Madam Prosecutor said today, that because there was a delay in charging you, she is reducing it even more to make the time less.
Do you understand? Because they had their warrant for a year and they didn't get you into court.
Yeah.
She took that into account in considering her plea offer. Okay, that's why you're getting the plea offer you're getting. Okay.
It's not a common reduction, so it's quite an extensive reduction. But you know, you can either take the plea or we can set it for a pretrial. So Ms. Underwood can explain it more to you or file her motions. So Mr. Shelton, do you have any more questions? Speak up a little bit for me.
I'm going to take the plea deal just to get out y'all way.
Okay. Well, I'm here all day, whether you're here or not, so you don't have to get out of my way because I do this whether you're in front of me or somebody else. So do you understand the plea offer?
Yes, ma'am.
Okay, so I'm gonna swear you in and then I'm gonna go through all your rights with you, okay? All
And
right,
I
so
did
can you
send
raise
a-
your
a
right
plea
hand for
form
me?
as well.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, so Mr. Shelton, do you understand the plea offer that Ms. McClure gave you would be that they will add a count 2 attempted assault of a prison employee, which carries a maximum penalty of up to 2.5 years in prison and or a $2,500 fine. She'll dismiss count 1, which is the 5-year assault of a prison employee, and she'll dismiss the habitual offender 4th offense notice. So do you understand that?
Yes, ma'am.
All right, and then there is no agreement on sentencing or fines and costs, correct?
Well, the agreement was constable and did the.
Okay, and Ms. McClure, is that correct? No objection, no position on the low end of the guidelines for purposes of sentencing?
That's correct, and I did forward a plea offer, which also indicated.
I
that-
can't hear you very well. You're kind of muffled for some reason.
My computer's glitching this morning. Is that any better?
Yeah, kind of.
I forwarded a plea offer. If that includes that Cobb's agreement, if it could be printed out for Miss Underwood and Mr. Shelton to sign this morning. But it does reference that, yes.
All right, I do not have that. It wasn't emailed to me. If you email it to me, I'll print it. Well, Miss Adams has it, so.
Sorry.
It's okay. Okay, so here you go, Mr. Shelton. She put it in writing for you. So, yep, looks like it's all in there, low end of the guidelines, and plead to an attempted assault of a prison employee with no subs. All right. So, I don't think I got to swear him in yet, did I? No.
Yes, you did.
I did?
Yeah.
Okay, so you heard all the discussions we've had this morning. Mr. Shelton, do you feel that you understand the plea offer? You don't understand the plea offer? Okay, so you're charged currently with assault of a prison employee. That carries a maximum penalty of up to 5 years in prison. You also have a habitual offender 4th offense notice. That means you have 4 prior felonies. You have assault of a prison employee on March 19th of 21, assault of a prison employee on March 19th of 2021, so 2 on the same day. You have a breaking and entering a building with intent back on August 14th of 2019. So let's see, we got 1, 2, yeah, 3. So that's your 3 prior. So this one makes a 4th offense. With that habitual offender 4th offense notice, if you were to get convicted at trial, you would have a life offense. So you would be sentenced to life in prison if you got convicted at trial because you have those prior felonies. Do you understand that? Say yes for me.
Yes, ma'am.
Okay. Now, the plea offer, when we understand you told me about this delay, the plea offer is to add a count to attempted assault of a prison employee, which carries a maximum penalty of up to 2.5 years in prison. But the Killebrew is a sentence to the low end of the guidelines. So if the low end of the guidelines are 5 months, then I'm going to sentence you to 5 months to 2.5 years. Do you understand that?
Yes,
What's your question?
The question is, I don't feel comfortable taking a plea unless if I read it's strange to me.
You got to speak up for me, please.
I don't feel comfortable out taking a plea if I can read this.
Okay, what do you want to read?
Here's.
Okay, you know what? This is great. Why don't you guys go have a seat over there and you read that to him quietly? Or you can use my jury room. I don't care. And then I'll move on to a motion I have. That way she can read through it with you. And you said you need her to read it too, right? Okay, so she will do that. Thank you. All right, so we'll see you back in a couple minutes. All right, Mr. Shelton? Okay, so Ms. Bruggeman, Mr. Cole, just gonna hang out with me for a while. Sorry about this. All right, this is in the matter of the people of the state of Michigan versus Wesley McCormick. We have file number 24-21705FH. I have Michael A. Is it Camorn?
That's correct, Judge.
Camorn P 47970 appearing on behalf of the defendant, and I have Jennifer Bruggeman appearing on behalf of the Lenawee County Prosecutor's Office. There are 2 motions. One is a motion to recuse or transfer due to conflict of interest, which involves a probation officer. So first I will tell you, I have no jurisdiction or authority over the probation department and who is assigned to handle cases, but I did bring in Larry Patton, who is the head of the Michigan Department of Corrections, and I let him review the motion and the transfer has already been done. All right, so I think Chris Jones has been assigned to represent him as a probation officer.
Okay, so that's all. So thank you, Judge. Appreciate that.
Okay, so then we are moving on to defendant's motion for order allowing the use of prescription dronabinol while on probation. Mr. Camorn, you may proceed.
Thank you, Judge. And I know we have a representative from the state. I don't know that I received a motion responding or a response motion.
I don't have a response. Did you respond, Ms. Bergman?
No, Your Honor, essentially our office is taking no position.
Okay.
That's good. It's good to know. Thank you, counsel. And I want to say just a preliminary matter. With that being said, my client is not trying to circumvent or not participate in the program. He's all in. He wants to take advantage of the opportunities. I'm not arguing about some of the cases. He finds himself in the situation. He wants to participate. As often the case, I wasn't there for the sentencing. Usually judges will say something to the effect of, these are the rules. I'm signing an order. If you can't comply with them, it's your duty and responsibility to come to me before you can't comply with them and ask for relief. And that's why we're here, Judge. I don't think this would constitute a necessary violation of the rules of drug court. For example, I understand opiates, if they're treated or prescribed by a treating physician, are not at issue for purposes of drug court or substance abuse court or any of the courts, specialty courts. And this particular prescription medication is a prescription. It is not cannabis, not marijuana. It's not a plant. This is actually a synthetically made. Like there's nothing in the item that he's placing into his body that comes from or originates from the cannabis sativa L plant that falls under the category of that would, if greater than 0.3%, fall in the category of marijuana. So I just want to make that clear. This is a prescription medication. It's a Schedule 3. It does not fall in the category of like a Schedule 1. And not that it's part of this case, but the category of Schedule 1 that it's not, has no medical value or is highly addictive seems ridiculous in today's age with it being legal in the state of Michigan. But putting that aside for a second, I know there's some discretion courts have in regards to cannabis, marijuana use while in the substance abuse court. We're not arguing for that. This is prescription medications. It's not something that would otherwise ever be precluded. I do recognize, and I think this was the underlying issue, that it is synthetic THC. There's no other cannabinoids that would originate in the plant. That's usually the basis of how you can tell the difference of the two. Synthetic THC would be only THC. And if you had any other, non-plant material that came from a marijuana plant, it would have the other cannabinoids like CBG or CBD contained in it. So I don't think, that shouldn't be an issue. In light of the fact that the state's not taking a position one or the other, I don't know that it's a contested issue. I would, I think that, the court has discretion. I think if this was any other substance other than one that has THC in it, it'd be not an issue. In fact, I understand he has been approved to use his Vyvanse, which is his prescribed ADHD medication. So with that being said, and proactively to avoid any violations in the future, I'm asking that you just grant our request for relief and allow him to use his medically prescribed prescription medication of Marinol.
Okay. The Illinois County Adult Drug Treatment Court Participant Agreement requires participants, and you had no position, Ms. Bregman? Okay.
That's correct.
And Ms. Bregman has no involvement with the recovery court. So requires participants to request and obtain permission from his or her probation agent and the adult drug treatment court team to take narcotic or addictive medications or drugs. And I'm probably destroying the name of this, but dronabinol is a Schedule 3 controlled substance. It is well established that it may be addictive or habit forming, and therefore requires permission from defendant's probation agent and the adult drug treatment court team before he may take it. He did voluntarily enter recovery court. And he's done moderately well, although we've had some dirty screens. His arguments that this court and the recovery court team have illegally imposed ourselves upon his right to medical treatment and medical privacy are both wholly without merit. The claim that the court and its recovery team are engaging in the unauthorized practice of law is also incorrect. His argument that he is entitled to a reasonable accommodation under the Americans with Disabilities Act is also incorrect. Mandating a drug treatment court to allow a recovering addict who voluntarily submitted to the rules, policies, and regulations of this intensive program to use an addictive medication would fundamentally alter the nature of the program, and the ADA does not require that the court take such action. Obviously, if this is something he feels he needs, we can let him out of the recovery court program and he can use it on general probation, but it is not something he can use as part of the recovery court. And so, we would not violate his probation if he wishes not to continue in the recovery court program. So that's a choice he can make, and he can discuss that with Mr. Jones. All right.
Is the court, and the reason, and I'm not arguing with the court, but just for clarity purposes, you're finding a distinction, for example, between the Vyvanse that he's been approved.
Vyvanse is a mental health medication, and we do mental health treatment. So no, there's a very different distinction. Vyvanse is not the same as dronabinol. So no, I am finding a distinction. So, I mean, that's just something he can take up with Mr. Jones. If he wishes to continue in the program, no, but if he wishes to be placed on regular probation, of course he can use it. Okay.
And is his Well, let me ask you this. If he changes into the consequence of moving to regular probation would be what under the terms?
Nothing.
Okay,
No, it would be nothing. There wouldn't be a violation for leaving recovery court.
okay.
So,
All right, so if I understand, the court's not inclined to allow it for those purposes, but it would allow it for general probation. He has no.
so recovery court, the whole purpose of recovery court is dealing with drug addicts. He's a drug addict. He shouldn't be taking drugs that would either be addictive or habit forming, because the purpose of it is to be free of all those substances.
I understand, but it is a prescription.
I've already ruled, so thank you. Are you ready on Mr. Schulten? Okay, will you prepare an order?
I will.
All right, thank you. Want to go back up to the podium, Mr. Schulten? Hold on, Mr. Schulten. We'll just let the attorney get his stuff. Thank you. All right, so Mr. Schulten, go back up with Miss Underwood. All right, so Mr. Schulten, have you had some more time to talk to Miss Underwood?
Yes, ma'am.
Okay, Miss Underwood, how does Mr. Schulten want to proceed?
First off, I would like the record to reflect, I took Mr. Shelton back. I read over the plea agreement with him, Your Honor. He signed it. I signed it. It's my belief Mr. Shelton wishes to enter the plea.
Okay, so she read everything to you, correct?
Yes, ma'am.
And do you understand everything?
Yes, ma'am.
And it's hard when you can't do that for yourself. So I appreciate your patience with us this morning. So do you wish to enter the plea today?
Yes, ma'am.
Okay, so I've already sworn you in, so you're already under oath. So it's your intention then today to plead to the added count 2 attempted assault of a prison employee, correct? Okay. Are you satisfied with Miss Underwood as your attorney and the advice that she has given you? You may not have liked all of it, but did she give you legal advice and explain things to you?
Yes, ma'am.
All right. Do you feel that she didn't explain anything to you? Are you satisfied that she's explained and read through everything with you?
Yes, ma'am.
Okay. And you understand the plea agreement would be that you would be sentenced to the low end of the guidelines, which Miss Underwood believes to be about 5 months. Is that correct?
That's correct, Your Honor.
Okay, and you understand though, because it's a 2.5-year felony, it would be like probably 5 months to 2.5 years. Do you understand that?
Yes, ma'am.
And then it stacks on the current sentence you're serving, right?
Yes, ma'am.
Okay. Now, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court other than what was placed on the record, which is basically a Killebrew for a sentence. Is that correct, Miss McClure and Miss McClure
Yes, that's correct.
and Miss Underwood?
That's correct.
Okay.
I should say, the guidelines could be lower.
Yeah.
But those are the worst.
Yeah. So you understand the guidelines could be even lower than that. Do you understand that?
Yes, ma'am.
Okay. Now, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights that you would have had at trial. Are we doing a no contest or a guilty plea?
Mr. Shelton.
Miss McClure, would you object to a no contest plea?
I have no objection to a no contest plea.
All right.
For potential civil liability.
Okay, thank you.
Okay. Could we do a no contest?
For civil liability purposes? Okay. All right. So, do you understand that I'm going to change your plea to a no contest? Do you understand that? And you want me to do that? Okay. So if a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. Are you okay? Are you nervous about something over there? Because you keep looking over there. Is everything okay? They're just here for me because they're training someone new. Okay? Okay. So if a guilty plea or a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and the court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that? Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that? So if you got convicted at trial, you have an automatic right to an appeal. Do you understand that? But if you enter a plea offer, then you have to apply to the Court of Appeals for a right to leave to appeal. So you have to ask them to let you appeal it. Do you understand that? It's different. Okay. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, Mr. Shelton? Okay, good. So you're going to be pleading no contest. So when I ask you this question, you can say no contest or not guilty, okay? So how do you plead to the charge that on or about January 5 of 2022 in Madison Township in the county of Lenawee, which I'm assuming is the Gus Harrison facility where you were at, that you did commit the offense under count 2, attempted assault of a prison employee? No contest or not guilty? Okay. Has anyone made any threats or promises to you to induce you to plead no contest to this charge other than what was placed on the record? Okay. Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that? Okay. Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
And Ms. McClure?
No, Your Honor.
All right. And you basically know what your sentence is going to be. So is it your own choice to plead no contest? All right. So who's going to place the factual basis on the record for me?
I did forward you a police report, but I can read off of that police report if you'd like.
That'd be great. I don't do the factual basis up here. So go ahead, Ms. McClure.
So I would just ask that we stipulate to the contents of the Michigan State Police report with incident number 141293-22, which was authored on March 14th, 2022, regarding an incident on January 5th, 2022 at the Gus Harrison Correctional Facility in Madison Township, Lenawee County, that at that time, Delmeke Shelton was a lawful prisoner of Gus Harrison Correctional Facility, and through a separate altercation between corrections officer Corey Keller and 2 other prisoners, that prisoner Shelton did throw his food tray at correction officer Keller and struck him in the right side of his head. There were no injuries as a result of that, but prisoner Shelton did not otherwise have any permission or anything of that nature to throw his tray at corrections officer Keller.
Okay. Any additions or objections, Ms. Underwood?
I think that's pretty accurate, Your Honor.
All right. So based on the facts placed on the record and from the information contained in the reference police report, the court finds beyond a reasonable doubt that on January 5 of 2022 in Madison Township in the county of Lenawee at the Gus Harrison facility, Mr. Shelton was a lawful prisoner at that time, And there was some kind of altercation with a couple other inmates and a correction officer. At that time, Mr. Shelton threw a food tray at correction officer Corey Keller, and who did not sustain any injuries. And therefore, the defendant did commit the offense of attempted assault of a prison employee. And I will accept the no contest plea. Has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has, Your Honor.
And Ms. McClure?
It has.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. There has been a plea agreement form signed by the parties, and the court will comply with that agreement. I'm going to refer this matter to the probation department for a pre-sentence investigation. I'm going to set sentencing for November 22nd at Miss Adams. Can I get another sentencing date? Because I have that sentence that I took the plea on today, and there's gonna be a lot of victims speaking at that one. So could I get another date from Mr. Shelton? Because I don't want to.
Mr. Shelton, do you want? Do you want to do something?
We're gonna do it in person, Miss Underwood.
We could do
In person.
November 21st at 8:15.
All right, so I'm going to set this for sentencing on November 21st at 8:15 in the morning. Where are you currently at? Are you at Gus Harrison still?
It's in Muskegon.
Muskegon, do you want it later in the day? It's fine. All right, so I'm gonna set it for November 21 at 8:15 in the morning. And then I'm gonna have it in person, so they'll bring you in person. And someone will meet with you to do an update probation by, or a pre-sentence investigation report. Because you pled no contest, you don't have to make a statement about what occurred that day. Do you understand that? But be truthful with them about your background, and then they'll prepare a report. Miss Underwood's really good about getting into MDOC, Zooming and meeting with people, but sometimes things happen at prisons and we're not able to get in and out. So if she can't meet with you in advance of sentencing to read it to you, I'll give her time that morning to go through it with you, okay? And then we'll have you in person. So I will see you back on November 21st at 8:15 in the morning. And thank you all for your patience with me this morning. Thank you, Mr. Shelton. Thank you. Thank you, Miss Underwood. No, Miss Underwood, I'm not gonna let you go anywhere. You cannot leave my court. So I have Mr. Koch. I don't know if you've had a chance to look at his paperwork, but I'm gonna hand you my file to look at. So Mr. Koch is an extradition from New Mexico.
Okay.
Never had one of those before. So if you want to go into to take a look at it and go talk to him in my jury room, you can do that. Okay. But Miss Adams, yeah, it's just New Mexico. So let me go through my docket. So hold on, Mr. Koch. She's gonna go back in and I'll put her in a room with you to Zoom. And Miss Underwood, Mr. Lofton doesn't want to come see me again this morning. Are you available to see Mr. Lofton at 1:30? Although it's a probation violation in his case with Mr. Murphy. So maybe Mr. Murphy wants to see him.
Is the probation violation connected to the case with Mr. Murphy?
It's just failure to appear and everything. So I think Mr. Murphy was the recent new public defender for him. So maybe we'll get Mr. Murphy here so he can handle all of them.
Judge, I got a call from the jail that they were trying to put him into the room.
Yeah, let me see. He might be in there. All right, go ahead and take a look at that, and then we'll do Mr. Koch. Let me see if Rodriguez is in there.
Your Honor, here's just that sign, please.
Oh, thank you. We'll send that.
Judge.
We'll put that. Yes.
I'm sorry. Back with Cody Gaish, he's on probation with Chris Jones, and was there a violation too? I don't think he pled to that. Or did I miss it?
I didn't have a probation violation file.
Okay.
That's already scheduled for the 16th as a pretrial, I believe. Yes.
Okay, thank you.
You're welcome.
Okay, I'll tell him.
Do you have, all right, so Mr. Coke, Miss Underwood's gonna go in back and Zoom with you real quick. And,
That file was there.
and,
So what am I gonna have this morning? The extradition?
and maybe Rodriguez Law. Unless Mr. Murphy wants to come do it. Okay, all right, so hold on, Mr. Coker. She's Coke, she is gonna zoom in from the back. Let's see what Mr. Lawson's up to. Not in there. In the matter of the people of the state of Michigan versus. What is this? This is. Hold on. Oh. All right, hold on, she's logging in. Okay, here's Miss Underwood, so I'm gonna bring her in and then I'm gonna put you guys in a breakout room. All right, so Miss Underwood, I'm going to assign the two of you to a breakout room and give you a moment to chat. All right, there you go. Go ahead and join that. I'm gonna take this files back to Miss Adams. Maybe, okay. Miss Spade.
No, that's okay.
I just want you to know, we got a milling cross for our jury trial tomorrow.
Oh my God.
Joanne, control yourself.
Oh,
I know you're
if I
upset.
could jump, I would. Oh, no kidding. Oh, I'll hobble back here and give it a hug. Oh. Don't be jumping up and down. I can jump. I can jump.
Yeah.
Thank you for that.
I know, now you have that visual.
Yes.
All right, Miss Underwood, let me bring him back. There he is. All right, so we are back on the record in the matter of the people of the state of Michigan versus Tanton William James Koch, file number 24. It's Tanton, right?
Tanton, yes, ma'am.
Tanton, okay. File number 24-21988AX. So Ms. Underwood, he had asked for court appointed counsel. I do believe he's eligible for court appointed counsel. And have you had an opportunity to speak with him?
I have, Your Honor.
All right, and do you know what he wants to do today?
It's my belief, Mr. Pope has no objection to extradition proceeding and proceeding with all due haste back to New Mexico, Your Honor. He has a life here and bills that are accruing, so he needs this to go through, I think, as soon as possible.
Okay, Mr. Koch, did they bring you copies to sign?
They brought them earlier, but they never brought them back. So.
Okay, let me call him again, except my phone is not working. Can you tell them you need the paperwork to sign again, or will they let you out of there to tell them that?
Yeah, I can open this. I think I could let them know.
Okay. And Miss Underwood, like I said, I don't know if you want to text Mr. Murphy to see if he wants to talk to Mr. Lofton.
Isn't there a case as well, Your Honor?
I have 2 box and a new file. The new file is Mr. Murphy's.
Can I get my paperwork? Oh, yeah. Thank you. 1 second. We're back downstairs. Thank you. They're bringing it right now.
Okay.
Has Mr. Murphy already dealt with the new file?
Mr. Murphy is the attorney on the new file that Mr. Lofton failed to appear for pretrial. So there's 2 box. Wait, let me double check. There are 2 box. I think they're box. Yeah, 2 violation of probation files and 1 new file. And on that new file, he failed to appear for a pretrial.
Your Honor, is that a resisting and obstructing?
Always, yeah, always resisting, obstructing. Yep, he's got assault of, yeah, he's got assault.
I believe it's the same one reflected in the violation of probation.
Yeah, I just didn't know if you wanted Mr. Murphy to take his file today.
Well, let me see. Let me see if Mr. Murphy plans on doing that. Okay.
Okay. Just let me know when they bring in the paperwork.
Will do, ma'am.
Okay.
Is Aaron Lindeman going?
Yeah, we haven't done that one yet.
Okay, okay.
Miss McGreen, I just sent you a chat.
Please.
I'll get you.
Okay.
Thank you.
Okay, so
got
you
my
got your
paperwork.
paperwork now, Mr. Coke. Do you have a pen?
Just grab
Did
me
they
a
give you
pen real quick. Yeah, I just asked him.
Okay, so, all right, so let me see here. Okay, so Mr. Coke, you had ample time to speak with Miss Underwood. Are you satisfied with her advice and her representation?
Yes, ma'am.
All right, and do you want to waive your right to extradition, to a writ of habeas corpus and go voluntarily to the state of New Mexico to face the charges made against you in that state?
Yes, ma'am.
Okay, so when they bring you a pen, right under waiver above certification by judge, there should be 3 or 4 copies. I need you, you're gonna date it and you're gonna sign it. And today is October 2nd of 2024.
All 4 copies of it?
Yeah, all 4 of them. Then I gotta sign all 4 of them too. There's like 1 for New Mexico, 1 for transport, 1 for the jail, 1 for us.
Judge, I responded to a chat message.
Yeah, that's what I wanted to do, Sierra. All right, Miss Adams, just tell the jail I don't have time to see Mr. Lofton this morning. And I'll see him this afternoon.
Your Honor. What I was going to do was simply enter not guilty for Mr. Lofton and have you set him for next week with Mr. Murphy.
So, I'm gonna send you a chat, Miss Underwood.
Thank you.
There you go. I just sent you a chat.
Yes. Thank you,
I'm
Your
gonna send
Honor.
you another chat. And my chat is, I'm starving
Thank you.
and it's lunchtime.
Thank you, Your Honor.
I don't want to arraign him when I'm hangry, right?
Okay. Then I will see the court at 1:30.
Yep. I have a swearing in at 1, so.
All right, I got all these filled out now.
You got it? All right, you
Yes,
want to
ma'am.
raise your right hand for me? How about your other right hand? There you go.
Sorry.
Do you swear that the signing of those papers is your free act and deed for the purpose of waiving extradition?
I swear, ma'am.
Okay, so they'll send those over to me. I'll sign them. You can put your hand down. They'll process it, send it back. And hopefully, they will come get you as soon as possible. If they haven't taken you in about 2 weeks, we'll bring you back, all right?
Okay, thank you.
You're welcome. Thank you.
Your Honor, can I ask what happened on Kenneth Baker?
Mr. Baker waived an attorney and pled guilty. So we have one last file, Ms. Underwood. We have in the matter of the people of the state of Michigan versus Aaron Scott Lindeman, 2 files, 24-21864FH and 24-21941FH. I do have a note from Mr. Coast stating that Mr. Lindeman tested positive for methamphetamine on September 11 and was warned not to use again. They set him up on colors. He's failed the test yet. He's missed 5 tests. I will be issuing a warrant for him for failure to appear, for a contempt for the drug screens. And then he has not appeared today at 8:30. It's now 11:49. I am going to issue a bench warrant for his arrest and set bond
Thank you, Your Honor.
$1,000 on each file.
Thank you, Your Honor.
Thank you. And I believe that concludes our morning docket, correct?
Judge, I'm sorry, you cut off. What was the amount on the bond?
Yeah.
$25,000 cash on each file.
Thank you.
Thank you.
Thank you.
And
Your Honor.
when are we doing Lofton?
Oh, we'll try at 1:30.
Okay.
Thank you.
All right. Thank you. And I believe that concludes our morning docket. Yeah. Okay.